All right, the court will call the case of the State of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
Mr. Eric Martin, please unmute your device, and state your name.
Can you hear me?
I can now, sir.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. The living sovereign, one of the...
Hey, I'll give it to him. All these court appearances have taught him to spell his name correctly and more succinctly. And as far as living goes, he'd have to demonstrate functioning brain cells for me to believe that assistant.
Assistant Public Defender Don Lebo as standby counsel.
Thank you. We're here for a pretrial today, and a bench warrant is still outstanding for Mr. Martin.
That's correct, Your Honor. As it relates to the pretrial, I believe the last time that we saw Mr. Martin, it was on December 7th, and he had some difficulty viewing the video that we had sent via flash drive. I encouraged him to get with his standby counsel, who at that time was APD Sandra White. He did not appear at that next hearing, but she did confirm that they had spoken almost every day, and that they had reviewed the video. So my understanding is that Mr. Martin has been able to view the complete discovery, including all of the media. I know that we were headed to a jury trial, so I will leave it to Mr. Martin to confirm that so we can get going with selection.
Mr. Martin?
Yeah, I looked at the video, and I found I looked at the video, and I also found some demands to dismiss, some self-incrimination based on the video, along with some others that have not been decided on, which should be decided on before any trial schedule or anything else.
Mr. Martin, I've decided on all the motions that you've brought before me. And the way this works is if I make a motion ruling, then the party making that motion has to prepare the order. So when you complain about no orders being prepared, that's your not preparing them, sir.
What do you mean not preparing?
I think my words were very clear.
I understand what you're saying. You're saying because I didn't file it as a motion or something? What are you saying?
Well, that to start, the court rules are very specific on how you file court documents like motions. I believe the term you use is demands, and there will be no demands for dismissal being granted today. And as far as the orders go in Judge Washington's courtroom, she requires a filing party to prepare her orders. So if you don't have a judge's orders denying your demands for dismissal, it's because you failed to prepare them.
Saying that I already ruled on them. So when I rule on them, it's up to the party to prepare them. That's you.
I did prepare them. Specifically, my demand to dismiss.
Sir, you did not prepare my ruling order, which was that they are denied.
What do you mean they're denied, but you didn't rule on it? How does that happen?
Do you have anything else? Yes, Ms. McDuffie.
I'm sorry, Your Honor. I did just want to clarify one point because Mr. Martin, I think, mentioned that he wanted to move to dismiss based on incriminating statements after he had reviewed the video. So I don't know if there's a sort of Miranda issue he's raising or not, but I would just, I guess for the record, remind Mr. Martin that when he appeared for the hearing on the 5 documents that he filed, demands, motions, whatever you want to call those, Mr. Martin, during that hearing, rattled off the fact that he did not have a valid license, his vehicle wasn't registered, and he didn't have insurance and didn't feel like he needed to do any of those things. So if there are any incriminating statements that would relate to the counts in this case, he has made them multiple times, including on the record in this court at his own hearing. So if any statements were suppressed from that media, they would still come in from statements he's made in court.
In other words, you had a Fifth Amendment right to shut up, but you lack the ability to do so. So while the prosecution will be providing video evidence, they don't actually need it because they could procure conviction based solely on the statements that you made on the record.
Well, I object to the third one is self-incriminating. As I pointed out and stated in my demand to dismiss, as the U.S. Supreme Court said, license ain't necessary. We're not using the streets for profit, which the cops have no evidence.
Mr. Martin, you're going to need to speak up if you want to have a transcript of this, because it's not.
I'm speaking up.
Let's see, Heather. Okay. Can you bring the microphone closer to you, Mr. Martin?
Yeah, let me see.
I'm sorry.
Kind of a little closer now. How's that?
Is that any better?
How's that?
How's that one clear? Yeah, please keep talking in the same volume that you're using right now so we can hear it.
So I object to what she just said about I made some self-incriminating statements. That's not true, because as I pointed out in my demands to dismiss, the law is in my favor, the higher supreme law, such as the statute, which is supreme law of the land under Article 6 of the U.S. Constitution. Federal statutes override state statutes, along with the Packer versus Banton case I cited and sent a quote from the law book on that clearly said from the U.S. Supreme Court that the people have a right to use the roads, not a privileged right. And as long as you're not using the streets for profit, which I wasn't doing, and there was no evidence, and the cops have no evidence of that. So I was exercising my right to travel, didn't need a license, insurance, registration, none of that.
And you just did it again. Stop telling on yourself. It's not helping your case.
So, nothing self-incriminating about what I say. There's no legit case here. And, which is why I beat a case on the same exact issue in Southgate. Same exact issue. Prosecutor moved to dismiss it because they know they hadn't to win the case. The higher law is in my favor. The state law is unconstitutional. That's assuming everyone's driving a motor vehicle when they're not. And I'm working to change that state law, and I'm going to. I already got a federal lawsuit filed on it in the Detroit courthouse on Lafayette Boulevard. Right now I got to fight one about filing fees, but when I overcome that, they'll be deciding on the merits, and I will be winning on that issue, and the state law will be changed. It's going to stop making the presumption, the state statute law, that everyone's driving a motor vehicle, even when it's not for profit. That's the problem with the state law. It's unconstitutional. Cops are blindly following that, acting as if that, and then the so-called courts are acting on that presumption. No, everyone's driving a motor vehicle, they need a license, insurance. So no, they don't. They're not doing it for profit. They're exercising the right to travel.
So, Your Honor, since I'm sorry, Mr. Martin. Since Mr. Martin has again made those same statements that I referred to earlier, and this prosecutor will not be dismissing anything in this case, we will be proceeding to trial if he doesn't want to plead to it. Let me ask the court if I could. Are we ready to set this? I understand he has a desire to file an endless amount of lawsuits and grievances and motions, but the court has indicated we are past that point. Are we ready to set this case for jury selection or no?
Yes, we are.
Thank you.
All right, any motion that was just made, whatever he's entitling that, is denied.
So you deny something, you don't even know what it is. But anyways, you still have, there's still demands to dismiss haven't been ruled on as a matter of law, which what a lot of them are, such as the state as a party. I filed a demand to dismiss because the state is the party here. Plaintiff. The state in this court, so-called court, has no jurisdiction, as I indicated in my demand under the U.S. Constitution. Only the
Sir, I'm not hearing those motions again. On October 26th, I made a ruling on all of those motions, and you have not prepared the order to that effect. We're done with those motions.
It's in order.
Is that the May jury selection, Your Honor? Or
no, it's not. We're going to do a July 25th July 25th final settlement conference.
Mm-hmm. Okay.
August 9th.
July 25th, 2024.
Hold on, let me write this down here. And I'm also going to make a demand right now for compensation also for this making me proceed against my will under threat and duress to these so-called court proceedings. in violation of my 13th Amendment right against slavery.
Well, I hate to tell you this, but slavery in America was only partially abolished if you go back and reread the 13th Amendment. It actually says that slavery is abolished in the United States and all territories under its jurisdiction, except for someone that's been convicted of crime. So once you've been convicted, the 13th Amendment protections no longer exist, and you can absolutely be held against your will without it being a constitutional violation.
All these court proceedings are against my right against slavery. So I'm entitled to compensation for all the court proceedings that I had to make in this case. Otherwise, I could have possibly been arrested. So it was only on the threatened arrest. It wasn't by consent willingly.
Mr. Martin knows that the jury selection is in person, correct?
I haven't finished telling him all of that yet. I'm getting the dates. I'm going to tell him in just 1 second. All right. The final settlement conference in this case is going to be on July 25th, 2024 at 11 a.m. And that is on Zoom. The August 9th jury selection is in person, and that's at 8:30 a.m. on August 9th.
Hold on. July 25th. 24, right? 8 p.m. a.m., you said, right?
It's at 11 a.m., sir.
I want to be understood. I'm not willingly giving up my right to be one of the sovereign people and by this jury, but
Jury selection is August 9th, 2024 at 8:30 a.m.
You said 24th?
It's at 8:30 a.m. I meant to say 8:30 a.m.
You said the 24th now, or you said the 25th?
August 9th, 2024 at 8:30 a.m. is the jury selection, sir.
I thought you just said 7/25/24.
That is the final settlement conference. That is on Zoom.
Hold on, I got one thing at a time. Okay, now let's do the, what's the other date now? August? What else?
August 9th
Okay.
at 8:30.
8:30, and what's that considered, what's that called there?
Jury selection, sir.
Now, which is in person here now? The 7/25/24, is that something I have to be there in person for? I mean,
For the fourth time, Mr. Martin, please listen. The first event, which is in July, is on Zoom. The last event is in person.
So we got it. So you're saying a whole bunch of wonders,
All right, we're done today. Have a good day, Mr. Martin. Bye-bye.
I love when judges just shut these jackasses down. I mean, I get Eric Martin seems like the type of person that most people just walk away from the middle conversation. So he's just looking for someone to talk to, but Judge Washington is like, nope, not today, and then boots his ass out of the meeting. All right, guys, that's the end of the video. His next court date in 148 isn't until July, but he currently has another court matter that he's going through in the 23rd District. So there's a good possibility that we'll be seeing him before then.